Welcome to a special edition of Legal AF. I'm Karen Friedman Agnifilo, and I'm joined today by the Manhattan District Attorney Alvin Bragg, who's just finished his first year as the new Manhattan DA. And boy, did he end it with a huge victory. 17 felony convictions against the Trump Corporation and their payroll company, both of which were sentenced this morning to a financial penalty of $1.6 million, which is the maximum allowable sentence under the law. And earlier this week, Trump's chief financial officer, Allen Weisselberg, was also sentenced for his convictions of 15 felonies. These are the first criminal convictions in the Trump orbit, and kudos to you, DA Bragg, for getting this done. As a quick reminder to our viewers and listeners, I worked at the Manhattan DA's office for almost 3 decades, and I was the number 2 under DA Bragg's predecessor, Cy Vance. But I myself have never worked with you, but I am so honored to have you here today since you've been carrying on the excellent traditions of the Manhattan DA's office, an office I love. And you're ending your first year on a very, very high note. So welcome, and thank you for taking the time to join me today.
Well, thanks for having me on. I appreciate it. Love talking with you always. So happy to now be doing it on the podcast. And you know better than anyone that the week, and I thank you for the kind words, is really just a continuation of the fine tradition here of being at the vanguard. I remember when I started out as a young associate at a litigation boutique focused on white collar prosecutions in the early 2000s, and this office was bringing seismic white collar case after white collar case, and the I think most famous occupant of the seat, Mr. Morgenthau, saying that we enforce the law from the streets to the suites. So I'm honored and humbled to be building on the work that you've done, and look forward to talking to you about it.
So congratulations on today's sentencing of the Trump Corporation. Tell us about this case, these convictions, Allen Weisselberg. We want to hear all about it from your perspective.
Look, it was. I love trials. It is to me like kind of one of the key heartbeats of our democracy. You take some folks off the street and put them in the box, as we say, and then they get to see and hear the evidence. And they got to hear about 13 years of tax fraud, of money that should go to the public fisc, lying, greed, all sorts of things like fancy cars and having executives getting monies paid off that weren't reflected on their taxes. And so it is the kind of hallmarks of a classic white collar prosecution, but obviously against the backdrop of a namesake corporation for a former president. So it took on additional consequence. But fundamentally, greed, fraud, lies, that's what white collar prosecutions come down to.
That's for sure. And the sentences that were handed down today was a total or an aggregate of about 1.6 million. Are you satisfied with that, with those sentences?
We wish we could get more under the law. We've started having a conversation with our partners in Albany. You were a part of pushing for Carlos's law, which is a law that recently was signed by the governor that heightens the penalties for workplace injuries and fatalities, a law that we support. We can't have malfeasance, corporate malfeasance that's significant in any way, particularly kind of systemic fraud that doesn't really get dealt with vigorously. Otherwise, the corporations will just price it in. It just becomes a way of doing business. So we definitely want the law to change. I do think here that the marketplace will speak, that a criminal conviction certainly will have a significant chilling effect. I know from my work as a public integrity prosecutor on bidding for public contracts. I think banks and others will think twice about extending credit and entering agreements with these convicted corporations. So encourage that there is some accountability, but wish that there would be more, and we'll push that for going forward. We'll get more penalties in these kind of cases.
Is that the part of the law that you think needs to change, that higher penalties for corporate malfeasance, for corporate crimes?
I think so, and we want to be thoughtful before kind of just adding to the penal law. But I do think this is a real hole that corporate actors, you can't jail the corporation, and obviously for a human being, the restriction of liberty is something that most people are going to think twice before committing a crime like this. But I would say for this kind of more than a decade, senior level, the highest levels of a corporation, systemic fraud, that having penalties that deter that will be good for all the other businesses that are following the law and for the rest of us taxpayers who are paying in. Judge Merchan, who I know and probably have appeared in front of, who presided over this trial at the sentencing of Alan Weisselberg, really focused in on some monies that went to allowing his wife to be eligible for Social Security, and said, this is pure greed. And what about this program that so many others actually need and are legitimately eligible for, or Medicare, which was part of the sentencing today when we talked about how Medicare was built. So these are important government programs, and we really need to send a strong message that we won't countenance this.
There are people who are asking why Alan Weisselberg, the CFO, only got 5 months, and why your office and you agreed to that plea deal with him. Can you explain your perspective on this? I mean, to me, 5 months for a 75-year-old, or truthfully for anyone for that matter, at the notorious Rikers Island, which, to be clear, is so bad, should be closed, in my opinion. It's not a walk in the park, especially if you're 75 years old, but there are people who said that's not enough time.
Right, and you unlike others know it so well, right? You know the conditions at Rikers, and you know what a case like this. So you mentioned his age, also the nature of the crime, right? So a first time conviction for a white collar crime, a tax crime, which certainly thought was serious and warranted prosecution. But when you look at other cases like this, it is a punishment that we think was warranted and fits. And as you know, and this is a hallmark of white collar prosecutions, the importance of a narrator, the importance of someone who was on the inside. And so we felt that in order to get his testimony about the inner workings of the Trump organization, and it's just a centerpiece of the trial. Like I said, I love trials. His testimony, which spread over 3 days, with him talking in detail about what he did, why he did it, his ongoing relationship with the Trump organization, which I think raised a lot of eyebrows on the jury. I think that testimony was invaluable. And in these kind of cases, it's called for, sometimes you got to make agreements with people who are complicit. They're the ones who know. And so it's something that we would do again. We felt that it was worthwhile so that we could prove the case against the Trump organization and get accountability for him. Like you said, 5 months on Rikers is significant.
Did the fact that that Mr. Weisselberg did not cooperate against Trump, in other words, didn't implicate him, does that affect any ongoing investigations or anything else, given his testimony with regard to that? So, for example, did he say anything on direct or cross at trial that Trump was not involved or in charge, or anything that could hurt either your or someone else's abilities, another prosecutor's ability to potentially prosecute Donald Trump or hold him accountable for some of these actions?
Certainly the defense, tried to pull out some threads to suggest that Donald Trump was, nowhere around, and that Mr. Weisselberg was completely rogue. The jury rejected that as part of finding the corporate liability. They have to find that the benefits to Mr. Weisselberg, these tax benefits, also were on behalf of the corporation. So we thought his testimony, advanced the case that was before the court. Certainly, as we've said, we are looking at other pieces, and obviously in Georgia, and the special counsel on the federal level, also a Manhattan District Attorney alum leading that work. Those, I think, all stand, kind of on their own terms. Certainly, ours is, other conduct in Georgia is certainly distinct from what we're looking at. So I think that the testimony advanced the objective at hand, which was the corporation convictions, and really made the point that the misconduct was on behalf of the corporation. The corporation benefited.
You were referring to the Manhattan DA alum special counsel. You mean Jack Smith? He and I actually were in the same very small bureau together and worked together in the early '90s. So
it's a fine tradition.
Yeah.
He's gone from the streets to the suites to like the international streets.
Yeah, exactly. He sure has. So, in addition, Alan Weisselberg also he also had to cough up a couple $1 million too, correct?
Exactly. So we thought that was important, of the financial. It's ultimately a financial crime, and that to pay back the money to the it doesn't undo the crime. It doesn't put the toothpaste back in the tube, but certainly is an important part of accountability.
So, what do you say about to people who say, well, 1.6 million is nothing to an entity such as the Trump Organization? And correct me if I'm wrong. The Trump Organization is the big umbrella corporation, and under it are hundreds of smaller corporations. The Trump Corporation and the Payroll Corporation, the two that you convicted, those are under this big umbrella Trump organization. And there are people saying that 1.6 million is nothing to them. That's a rounding error, if you will. And so, how is that going to prevent not only others and deter others from committing this kind of fraud? Won't the Trump Organization, for example, just close up the two convicted businesses and open up two more, or fold the duties into one of their other ones and just walk away and call this yet another loss that he can claim on his tax returns and not pay income tax?
I think those are all significant points. The high profile nature of this, I think, makes it difficult to run away from it. So it's something that I think the marketplace will know, and the collateral consequences. Certainly, when you're filling out, for example, a public bid, and they've got some public contracts. I think this is the kind of even if you reorganize, the kind of conviction that would need to be disclosed. So I think it will be hard for them to distance themselves from this conviction. But your points are well taken, which is why we think we need stiffer penalties for this kind of ongoing pervasive fraud by a corporation.
Yeah, I agree with you. The penalties need to be significant enough so that this doesn't just get built into the cost of doing business for companies, right? That will really be a deterrent.
Exactly.
These are just astounding, significant victories, in my opinion. What does this mean to the office and to your administration?
And I think you'll appreciate this, more than almost anyone else. What I think it means for the office is another opportunity in the long history of the office for the public, and we work for the public. We stand up and say, we represent the people of the state of New York. For the people of the state of New York to get to see Susan Hoffinger, Joshua Steinglass, who I know you work with and oversaw his work, and the others who worked on this case, to get to see the rigor, the professionalism, the integrity that we stand at the ready. I think it's really good for the public who we serve to see that, and I think it's good for the office. It sends a message to the defense bar, to potential wrongdoers, that we stand at the ready and are prepared. I think it's always good to show the trial readiness of any office, and I'm just really, really proud to be a part of the tradition. Proud of our, I've talked a lot about the prosecutors. Our analysts. The role that the analysts you play. Paralegals, just putting it together. It's a whole team effort, and so I think it's great for other parts of the team to get to see the work that we're doing. The only thing, as I say that I would hasten to add is, this trial got a lot of attention, as I think was warranted. But as the number of trials that happened in the courthouse during this one were a large number, and they're all important. All important, to the victims and the survivors, and the same level of rigor and professionalism goes into each and every one of them. So I want the public to know that as well.
And I think that's an excellent point. And you're right. I used to get frustrated that, you'd only hear about certain high profile cases when there were other very, very, very serious, complicated cases going on at the same time, with also excellent work. And the office does a lot of that. Speaking of Susan Hoffinger and Josh Steinglass, so you were handed this case when you were when you took office. It was already indicted under the previous administration. But you're the one who chose who was going to staff the case, right? Who's going to try the case. And you put Susan Hoffinger, the chief of your investigation division, who has both substantial prosecution and defense, criminal defense experience. And she has a reputation of being an excellent trial attorney. And I thought that was an excellent choice. But really interestingly, what you also did was you staffed it with Josh Steinglass, who, as you said, I've worked with for many years. He, to me, was an interesting choice because he's mostly known as a violent crime prosecutor. You know, he's your stable of thoroughbred racehorses, you know, as a senior trial counsel, which is sort of, in my opinion, the most elite role at the Manhattan DA's office, and has a lot of experience. But that was really, I think that showed a lot of foresight on your part to staff it with those two as a pair. And I know there were others on the team as well. Tell us what went into this trial strategy and staffing of the case in this manner.
I was so happy, and it's great to see. You know, they did not know each other really well before, and you know how these things work on trial teams. You know, now they're fast friends, and you see the dynamic, and the pairing ended up being phenomenal. You know, mentioned
It could go
Susan.
either way, by the way. You're either best friends at the end of the trial or the opposite.
I'm good friends with all my trial partners. Sometimes in the middle of trial, you know, it gets a little tense.
Yeah.
But you know, you could just see that they really had a real chemistry, and I think they complemented well one another. What I was thinking about when we put the team together was, you know, when I recruited Susan to the office, I knew her by reputation. We hadn't worked together, but I knew the trial reputation in building complex cases, and so I thought that having her on, someone who's been a part of high-profile white-collar trials before, would be important. And then when we started thinking about the pairings, I'm a generalist, right? I've done, you know, federal prosecution, state prosecution, you know, civil, criminal, white collar, street crimes, and so I've done in a lot of my sort of management, particularly at the New York Attorney General's office, a lot of cross staffing, and have found that when you bring someone in from a different area, they just see linkages and make connections that someone who may be steeped in that area doesn't. So it was important to me that, you know, he didn't come in as a tax expert. His expertise is speaking to Manhattan juries. He does that. He does that phenomenally well. As you said, all of our senior trial counsel. You know, I'm new here. One thing I've learned this year is just that role. All of those folks are so dynamic and so good. And in some ways, it was really important that he hadn't worked. You know, he wasn't a tax expert. What he's an expert in is explaining things to juries, right? So, you know, this tax stuff could be mystifying and, you know, could be intimidating to a jury. So I thought the pairing of someone who'd done a lot of white collar work was great on our feet with someone who, as you say, is most known for his street crime trial work, but bringing that narrative and that storytelling. And you know, if you'll indulge me, I can have this written down. I thought he had a great line in his closing, which he repeated in the sentencing today. He said that the scheme was far-reaching and brazen. It was deep, wide, and long. And you know, as a trial lawyer, I love threes. There's some research on saying things in threes. So he said deep in terms of the robust array of the practices, wide in terms of the number of beneficiaries, and long in terms of its duration. I mean, that's the kind of stuff, like, you know, that sticks in a juror's brain and brings it to life. It's not a tax case about, you know, the IRS code and the state tax code. No, it's a case about greed and lies, and it's deep, it's wide, and it's long, and that's I think the beauty of having Josh on the team, and so we were really happy about that pairing.
Great. Well, I think it was great. I thought it was brilliant. One last question about the case, and then I want to pivot. So these convictions, to be clear, are for state and city tax violations, correct?
Right.
So does that mean Weisselberg and the Trump Corporation still have potential federal liability with respect to the conduct that came out at trial? And do you know whether there's an active federal investigation into this?
I don't know. I don't know. You know, we focused on, you know, just sort of the charges that we had jurisdiction for. You know, I don't know. My sense, just, you know, I don't want to speak for the federal government. My sense is that probably this will be the last word in terms of a criminal prosecution, given the outcome here. But that's just speculation.
So just pivoting now to the broader Trumps and Trump investigations, we know it's been widely reported that there's at least one, possibly more than one, open and active criminal investigations still ongoing in your office. And you've spoken openly and made the comment that there are ongoing investigations with respect to the Trumps as individuals. So I'm not going to ask you specifically about them, and many people don't understand why that is, but you really can't talk about an ongoing investigation. And you're not alone in that. Prosecutors, all prosecutors, generally don't do this ever, not just you. It's the very rare time that they have to. And I would love if you could explain why this is so, whether you're Jack Smith, whether you're Alvin Bragg, whether you're Cy Vance, Robert Morgenthau, or every other prosecutor across this country, why it is so important to allow criminal investigations to go on and go on not necessarily in full view of the public.
I'm so happy you asked me that question. This is something that, has been on my mind a lot this year. We've got, cases, we've worked on throughout our careers. Some of them get media attention, some of them don't. Obviously, the attention on this is a lot. Uh, but it's the same principles that apply. And you said, and I would add another name to that list, Judge Garland, has been also, dealing with this issue of when to speak and how much to speak. And we obviously want the public to have confidence in the administration of justice. And sometimes being quiet means that false narratives abound, and it can be difficult. I found that to be challenging, but it's remarkable when we speak prior to the closing of a proceeding outside of court. So when we issued the statement last year that the investigation was ongoing, that was with a lot of introspection and thought, because even that statement was remarkable and something that we would not normally do. And it's to protect the integrity of the investigation, as you know. Um, First and foremost, there's privacy interests and liberty interests for the people who are under investigation, for potential witnesses. That's why we have, in part, grand jury secrecies, so people will be able to come forward, and it won't be public, and so they'll share and testify truthfully. We also don't want to have the public discussion about what a witness says. And one, we have those privacy interests. Two, that might muddy the recollection of another witness. And so we have really strong privacy, confidentiality, hallmarks. And this is not something that just reasonable minds have come up with, right? These principles are embedded in the Code of Professional Responsibility, which govern all New York lawyers and their analogous codes throughout the country. So they're really, really strong principles that we abide by in every case. But in a high profile case, it means that sometimes the silence comes at the expense of other narratives getting out there. And then we got to ask ourselves the tough question, when to speak, to correct the record, whether we should, and to be very, very careful and judicious about it. And here we had sort of an additional complication in that we had this trial. So we have the investigation that's ongoing that we're not talking about. And if we even found our way to saying we should maybe say something, and there's something permissible we could say, we then would have to think about, well, are we going to prejudice this trial? Are we going to, is it going to lead to some sort of a mistrial motion because of the impact it would have on the jurors? And so, that underpins a lot of this thinking too, is pretrial publicity and the effect on a potential jury pool should a case be brought.
I'm glad you mentioned Merrick Garland, but it was Bill Barr, it was all the U.S. attorneys that were appointed under Trump. I mean, this is not a Democrat or Republican thing. This is prosecutors. And politics do not belong in prosecution. Everybody who's ever prosecuted a case says that as well. But you do have active ongoing investigations, correct?
Yes, we do.
And are these joint with the Attorney General's office, the New York Attorney General's office, or is it just your office, or can you not say?
So we've been working. The Attorney General's been a partner. Gary Fishman, who's special ADA on the trial that was just concluded, was with us today. Jennifer Levy, who's the first deputy at the New York Attorney General's office, joined us for the press conference. So it's a strong partnership, and one that continues beyond this case.
So the Trump Organization this morning, after this conviction, or after I should say the sentencing, called the prosecution politically motivated and said that you would stop at nothing to get President Trump. What do you have to say about that? Because, in fact, you were actually handed another case that was widely reported that some people thought was ready to go into the grand jury when you first became DA in January against Donald Trump, but you've slowed that down and put the brakes on that early on. If you were politically motivated, you would have just brought that case, but I have to say, you're not only just bringing cases, you're bringing cases without fear or favor and waiting until you can prove them beyond a reasonable doubt. So, I just wanted to kind of point that out because I was really irritated by that statement. I'm sure you were too. But you've widely said that case is still open too. Is that correct?
Yes, and look, I appreciate it. I think the former president is no longer on Twitter, if I'm right. So I don't know how the statement was released. I do not, follow or put much stock in those words. We are doing, what you and I have done for, together probably 40, 50 years, which is the tradition of the office and prosecutors everywhere, which is, following the facts and applying it to the evidence. Sometimes that means that there's a conclusion that the public loves, and so be it. Sometimes there's a conclusion that the public doesn't like, so be it. We've got to do our job, and I think the confidence in this is something that I think across the board, not just in the white collar space, but more generally, sort of confidence in the system is something that I view as really, really part of my job to keep a focus on. Particularly at this time of, and some could trace it back to Watergate. There's obviously a lot of, scholarly literature on this, but sort of declining faith in various institutions, including government and including particular, prosecutors. I spent a lot of my career doing public corruption prosecutions, and kind of defense 101 in those cases is to say, it's politically motivated, and I would always point out to people I've prosecuted people of both parties, sometimes in the very same case, and you just go where the facts take you, and do it with rigor and professionalism. And what I've learned in this new seat is that you do have to sometimes point out what you just said, which is explain and give some context when you can permissibly do it. But end of the day, we'll keep on following the facts and doing the work that's been done here for generations, and the work that's being happen, as you point out, prosecutors' offices, and I think ultimately, the work in the courtroom speaks for itself.
One last question before I ask you any last thoughts you want to share. The Stormy Daniels hush payments investigation, in my calculation, the statute of limitations on that is going to run at some point this year. So we should know one way or another whether or not there's going to be a case if it ends with a prosecution, for example. But if it ends without a prosecution because you just don't have enough to charge that, is that something you think you'll communicate publicly about?
So we've said in our statement in April that we will communicate our conclusion, and if it's an indictment in a matter, then that obviously will speak for itself. And if we don't, then we'll communicate it. And as we've been talking, that is in and of itself, I think, not something that prosecutors have traditionally done. We did it in certain types of cases at the Attorney General's office. I think we see sort of over time more and more. There's some really good for the wonkier parts of the audience. There's some really good scholarship in this case. Jessica Roth at Cardozo, who was a alum of my old office, Southern District. Becky Royfey, who's a professor in New York law, an alum of the Manhattan DA's office, have kind of written about and talked about when prosecutors should talk. Others in this space too, Bruce Green at Ford. It's a really rich area, as with our good friend, the dean of New York Law School. I spent some time there, and so this is an issue that's really rich. And I think about and really trying to apply those theoretical principles in practice here. But yeah, we're committed to speaking and letting the public know at the appropriate time. And if it's by way of indictment, then that document will speak. And if it's not, then we will articulate our conclusion and our basis for it in a statement.
Well, I promised the press office that I wouldn't keep you too long, and so I want to keep that promise so that hopefully they'll let you come on the show again in the future. Are there any last thoughts you want to share before we end and say goodbye?
No, it's just great talking with you, and I love the podcast. I love this conversation, and looking forward to coming back on again. And thank you for your work. I love the things you're doing now, but in my mind, you're still a public servant. And thank you for talk a bit about the history of the office, and so thank you for being an important part of that history. And I'm looking forward to talking to you again.
Well, thank you so much for being on the show. It's really a pleasure to talk to you. And thank you, really, more importantly, for the incredible work you're doing, both for New Yorkers, but as well as the American people. So thank you for being here.
Thank you.